Today we're going to talk about OTA appeals. How do you go about building a California tax appeal record that can actually win? Many taxpayers treat, and the representatives treat, an Office of Tax Appeals filing like a simple disagreement letter. Listen, that's a serious mistake. An OTA appeal is not a casual correspondence. It's a formal administrative tax appeal where the taxpayer must build an organized evidentiary record that is capable of overcoming California tax agency's original audit position, which is a tough burden. You carry the evidentiary burden. You must establish that both the law and the facts are on your side. Hi, I'm David W. Klasing. I'm a dual licensed tax attorney and CPA, and I'm the owner of the tax law offices of David W. Klasing. We have over a dozen offices across California to serve you. Today I'm going to explain how OTA briefings work, why the opening filing matters so much, and how weak records can quietly destroy an otherwise defensible California tax case. So what really is the OTA? The California Office of Tax Appeals, or OTA, is supposed to serve as an independent forum for disputes involving the Franchise Tax Board, the California Department of Tax and Fee Administration, and certain other California tax matters. But taxpayers should understand that the burden of proof usually remains on them. One of the biggest strategic traps in an OTA appeal involves the opening filing itself. Under OTA procedures, the original appeal letter may become the taxpayer's opening brief unless a supplemental brief is properly requested. In essence, what that means is that a rushed or unsupported filing can accidentally become the foundation of your case. So what is a strong opening brief with the OTA? What does it look like? A strong OTA brief does not simply argue that the original California agency involved is wrong. The appeal has to organize facts, timelines, documents, accounting schedules, legal authority, and most importantly, evidentiary support. The goal here is to create a coherent record that gives the OTA panel a reason to reject the original California auditing agency's assumptions. Evidence matters far more than any verbal rhetoric here. While the OTA allows relatively flexible evidentiary rules, unsupported statements still carry very little weight. Strong OTA evidence often includes things like bank records, federal transcripts, general ledgers, point-of-sale system exports, and declarations under penalty of perjury, and third-party records. The evidence here must do the work that oral argument alone cannot do. So what are some of the high-risk fact patterns that may be involved in the underlying audit that are dangerous to bring before the OTA? Listen, some cases involve far more than just tax calculations. If your underlying audit includes cash skimming allegations, false invoices, concealed income, altered books, or badges of fraud, then every single statement inside that OTA brief may later matter in a civil or criminal tax proceeding. This is not the place or the forum to improvise facts or try and clean up your story after the fact. Oral hearings here do not fix weak briefs. Many taxpayers, more like their representatives, believe that they can effectively explain everything later during oral hearing. Listen, that's dangerous. The oral hearing should clarify the written record, not create it from scratch. A weak written record usually remains weak even after very strong live testimony. So, in closing, if you're preparing an OTA appeal involving the CDTFA, the FTB, whether it be a sales tax audit, a residency audit, or an income sourcing issue, or penalties, the brief itself that gets you in the OTA may determine the outcome of that appeal. At the tax law offices of David W. Klasing, our dual licensed tax attorneys and CPAs help taxpayers build organized evidentiary records that are designed to withstand scrutiny, also minimizing civil and criminal tax exposure. Call 1-800-681-1295 or visit klasing-associates.com to schedule a confidential reduced rate initial consultation today. You won't regret it. Dave Klasing, Tax Attorney CPA.